if I catch a doctor in a lie during cross-examination, do I go ahead and beat a dead horse? Do I repeatedly show to the jury that this doctor has lied? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so let's say this is a medical malpractice case, and one of the doctors who we are suing, or even a medical expert, is up on the witness stand. And now I'm cross-examining the doctor. If I determine that the doctor has lied about something in this case, based upon something he has said in the past, do I go ahead and point that out to the jury? You want to know? The answer is absolutely, yes, I do. But what happens after I do that? Do I repeat it? Do I pretend I didn't hear it and ask the doctor to say the answer again? There are some attorneys who will do that, and that is a strategy. But what happens after that? After you've done it twice now? Do you do it again? Do you say, I'm sorry, doctor, I didn't hear it. Could you say that again? Or, Madam Court Reporter, could you read the answer back again? I'm sorry, I didn't hear all that. And now it's obvious to everybody in the courtroom what you're trying to do. You're trying to get them to hear it not just once, not twice, maybe even 3 times. There will come a point where trying to do it even more is ridiculous. Why? Because the jury heard it the first time. The jury heard it the second time. And are you really going to go ahead and have the jury hear it a 3rd time? No. The better practice is to turn around and after the first time that you caught the doctor in the lie, don't even mention it. Just move right along. You want to know why? It's because I'm now going to save the best part for closing arguments. That's right. I catch the doctor in an inconsistency. I catch him in a lie. And now, instead of coming right out and say, Doctor, are you lying now or were you lying then? No. That's argumentative. That doesn't accomplish very much. Instead, the better practice is to wait until closing arguments. Why? Because now the doctor is no longer in the witness stand. He no longer can answer me back. He no longer can say anything. And by the way, the opposing attorney can't say anything either. He has to wait until it's his turn to make closing arguments, assuming, of course, he hasn't gone yet. And in a medical malpractice case in New York, guess what? The defense lawyer goes first. So now, when I get up to make closing arguments, the defense lawyer no longer has an opportunity to rebut anything that I'm going to say. So, now during closing arguments, that's the perfect time to go ahead and point out the inconsistencies to the jury. Ladies and gentlemen, did you hear Dr. Jones? Did you hear what he said? He said one thing 2 years ago during his pretrial testimony. He said something totally different at trial here. And now I can go ahead and play up the fact that he no longer has any credibility. And if you can do that, all of a sudden, then what happens? Now there's nobody to answer you back. There's nobody to change the story. If the doctor was still on the witness stand, and now I was playing to the jury and saying, excuse me, doctor, I'm sorry, I didn't hear that. Could you say that again? Or Madam Court Reporter, could you repeat that, what he just said? I didn't hear that. Judge, could I ask him that question again? I'm sorry, I think everybody in the courtroom needs to hear it again. No. Now I can take the transcript out, and I can stand in front of the jury during closing arguments, and I can actually read word for word that inconsistency. And then I can play it up and say, do you want to hear that again? Did you hear what he had to say? And now again, it all goes back to his credibility. The point is, make it once, highlight it on cross-examination. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases in New York. You know, I do understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day. Bye-bye, everybody.